What is a remand for joint dismissal without prejudice for unmarried sons? Imagine your immigration case being sent back to the start, but with a chance to pause and reconsider. That's what a remand for joint dismissal without prejudice means in family-based immigration. When a case involving an unmarried son of a U.S. citizen is remanded for joint dismissal without prejudice, it's usually because both the applicant and the government agree to end the case temporarily. The higher authority, like the Board of Immigration Appeals, sends the case back to the immigration judge with instructions to dismiss it together, but without permanently ending it. This type of dismissal is called without prejudice. That means the case is closed for now but can be reopened later if needed. For example, if the unmarried son is planning to do consular processing outside the United States, this pause allows him to focus on that process without the immediate threat of deportation. It also gives him time to explore other options, like adjusting his status if circumstances change. In family-based immigration, especially for unmarried children of U.S. citizens, this process can be very helpful. It allows families to coordinate their plans better. If the case is dismissed without prejudice, the person can refile or restart the process later. This flexibility is useful if there are delays in visa processing or if additional paperwork is needed. The remand involves sending the case back to the immigration judge, who will carry out the joint dismissal. Both sides agree to end the case, but it's not final. The government still has the right to reopen the case later if new issues come up. This process helps families manage complex situations without losing their place in the immigration system. For families navigating the family preference categories, like unmarried sons and daughters of U.S. citizens, understanding this process is important. It can help them avoid rushing into decisions and give them time to prepare for the next steps. If an unmarried son is in removal proceedings but plans to get a visa abroad, a remand for joint dismissal without prejudice can give him the time he needs. It pauses the case, so he can focus on completing his visa application without the risk of immediate deportation. In simple terms, it's a way to temporarily close a case with the option to reopen it later. It's a strategic move that can save time and reduce stress for families trying to reunite or adjust status. Remember, this process is often used when both sides agree to pause the proceedings, making it a helpful tool for managing immigration cases involving unmarried children of U.S. citizens.